The 3 strategies I am going to discuss in this video could possibly give you a shot at a big payday if you've been injured in a car accident in Louisville, Kentucky, the city that I represent injury victims in. I've seen these strategies work time and time again against insurance companies, even when I used to represent insurance companies in court years ago. To teach you how these strategies can work in a real-life case, let me tell you the story of my past client, Leo. Leo was in a car accident when he proceeded through a green light and was struck in the intersection by another vehicle. The other driver apologized for the accident and admitted he was at fault at the scene of the wreck. Due to the accident, Leo sustained an aggravation to his neck. You see, Leo had suffered from problems with his neck for years prior to the accident. The accident was the last straw, though, as it aggravated the condition of his neck to the point that surgery became necessary. And in less than a year and a half after the accident, Leo ended up having the surgery on his neck. After his surgery, my office gathered up Leo's medical records and bills. And this leads me to the first winning strategy I will discuss, and that in most injury cases, you should wait until you are done treating or at least reach maximal medical improvement before trying to settle your case. The only time I would not recommend that you wait until you are done treating or reach maximal medical improvement to try to settle your case is if you know your case is worth over the available policy limits. This can sometimes be tricky because the at-fault driver's insurer in a Louisville, Kentucky car accident case is not required to disclose to you the amount of their insurer's policy limits prior to you filing a lawsuit. You should know that the Kentucky state minimum required per person policy limits in Kentucky is $25,000 though. If you are unsure what the other driver's insurance policy limits are and you have a case that may exceed $25,000 in damages even early on in the case, you may consider making a demand in your case at an early stage. But in Leo's case, I was made aware that the policy limits of the other driver were 6 figures, and I also knew that my client had 6-figure policy limits available to him under his underinsured motorist insurance coverage on his automobile insurance. As such, like in most car accident injury cases, it was best for Leo to finish his treatment and complete his surgery before sending his written demand package. So in Leo's case, after my office obtained the surgery medical records and bills for Leo, I sent a written demand to the other driver's insurance carrier demanding that they pay out the insurance policy limits. And this leads me to my second winning strategy. To initiate settlement negotiations, send a written demand via letter or email to the insurance adjuster demanding that they pay out the policy limits. In my opinion, it's almost never a bad idea to start off the negotiations by simply demanding that the insurer pay the policy limits. This will force the insurer, if you have a viable liability claim against their insured driver, to either offer to pay the policy limits or make you a specific offer for a specific amount of money. By demanding the policy limits, it gives you a shot at the potential biggest amount you may be able to recover by way of a settlement in your case. And in Leo's case, after I sent the written demand to the other driver's insurer, and with very little fight, the other driver's insurance company quickly agreed to pay out their 6-figure insurance policy limits. But we weren't done there. You see, Leo also had underinsured motorist insurance coverage on his automobile insurance policy. Underinsured motorist insurance coverage is a type of insurance coverage on your automobile insurance policy that allows you to pursue a claim for your damages in excess of any at-fault driver's insurance policy in the event that the at-fault driver does not have enough insurance to cover all your damages. So after settling for the policy limits with the at-fault driver's insurance company, I sent a written demand for the underinsured motorist insurance policy limits to my client's automobile insurance carrier. And this leads me to my third winning strategy. Include an expiration date on your written demand. In Leo's written demand, I included an expiration date. I advised in the demand, in writing, that the underinsured motorist insurer agreed to offer the policy limits by at least 5 p.m. 30 days after the date I sent the demand. I also advise that any counter offer 1 penny less than the policy limits will be deemed rejected. By putting an expiration date on the written demand, it puts pressure on the insurer, because all insurers have a duty to act in good faith. And if you have a case potentially worth above the policy limits and the insurer does not offer the policy limits within a reasonable time, like 30 days after your demand, it could possibly be argued the insurer acted in bad faith, meaning the insurer may be on the hook to pay out more than the policy limits eventually. Your written demand with the expiration date gives the insurer the opportunity to act in good faith. But if they fail to make you a good faith offer within the date of your expiration date, it could potentially set up a separate bad faith claim against the insurance company, leading to the insurance company to have to possibly pay out even more money to you. The thing is, I only went over 3 winning strategies for Louisville, Kentucky car accident injury claims in this video. Even though there are more winning strategies one can implement to potentially get a big payday after their car accident. And in this video about to pop up right here, I will tell you yet another winning strategy of how filing a lawsuit in your injury case can usually get you paid more for your case if you're getting a lowball offer from the insurance company. Lastly, if you've been injured in Kentucky, remember to don't wait, call Tate.